we are right on time to introduce Megan, whom I've seen joining us at some point. Megan, there you are. Fantastic. I know it's an early start for you as well, like it was for Fred as well. So thank you so much for accepting our invitation. We've tried to put you as far back in the schedule as we could, but it's still a fairly early start. So Megan is a residential fellow at Codex, right? You received your PhD from Sciences Po, and you also were a lecturer there, where you taught courses in artificial intelligence and recursive reasoning. So I take this domain and the things that we are discussing today around sort of accessibility of legislation, the way in which we can use technology to improve that accessibility are pretty close to your research interest. I know that you're working right now on sort of the limits of legal expression and how code can be used as the next sort of legal language, which is a concept that I'm sure Luke and Bridget will relate to. You've been working quite recently on the frameworks of legal interpretation and sort of overlaps with linguistics, logic, static programming, and so on. So I think you're perfectly equipped to guide us through your presentation now. We're really curious and interested in hearing your perspective on sort of the role of language in law, which I think will be the topic of your presentation, and what it reveals for future codifications of law, where code may not mean code in a legal sense, but may mean code in the terms of programming code. So the floor is yours. Thank you so much for joining us. We're really curious to hear your perspective on all of this.
Yeah, thank you so much. It's a pleasure for me to be here. So let me just share with you a few slides I've prepared for today. So hello, everyone. Thank you again to the organizers of the hackathon, as well as for the kind invitation from Professor Barraza, the Legal Innovation Lab, Legal Tech Wales, to be here. Today, as Professor Barraza sort of probed at this, I hope to discuss with you today sort of two key questions. And one is the role of language in law, and two is computer code. Could both either formal and programming languages be the next legal language? The former teases at this proposition that has either been taken for granted or has been a puzzle to scholars in the legal field. So, and that is, law has language at its core. In fact, in the United States, we have seen this kind of fervor around the notion of textualism and a fanaticism around how law should adhere to the words of the text. But what language are we really talking about here? Much of legal writing at the moment is captured in what we call natural or human language. Yet it appears that only a relatively small section of the population have the tools to decipher this rather opaque and even esoteric language. That is, the text itself is sort of frequently seen as a barrier, a moat to access. In fact, renowned legal scholar David Mellenkopf described the law as a viscous sea of verbiage. I always open with this anecdote, but one of my first experiences teaching, I taught a course called Legal Semantics. And as an icebreaker, I asked my students, what made you excited about this course? What made you join? And the answer I got from one of my students really stuck out to me. And that was, well, I really want to deploy legalese in my everyday life. And that's when I thought, maybe the legal language is something else. And so I started to explore how legal language is unlike other technical languages. This is because natural language and the art of its use is a centerpiece to the equation. It is then assumed that there is some presumed set of vocabulary and a specific method of deployment, definition, phrasing, and usage that distinguishes legal from plain or other technical languages. In California, where I currently reside, the court most recently determined that bees are legally fish. This, at first blush, angered actually those who were in the fields of biology, zoology, for how on earth can we classify bees as fish? This, of course, is not the first time that the courts have decided that apples are indeed oranges. Ultimately, the reasoning behind why bees are fish was for environmental protection reasons. But if you look at sort of prior case law in other instances, such as Nix v. Hayden or in White City versus PR Restaurants, we saw that the categorization of food items, so in the former, tomatoes were deemed as a vegetable instead of a fruit, or in the latter case, where burritos, whether or not they were actually inclusive of the category of sandwiches, they all had these significant legal and financial implications. Perhaps actually one of my favorite cases was a 1986 case from the Utah Supreme Court. They determined that a man was driving under the influence when he commandeered a horse, while of course heavily inebriated, and went for a joyride. Although, would his motor vehicle insurer ever thought that his horsing around was deemed as driving recklessly? And then should insurers consider horses as vehicles? Further to the law's peculiarities, Richard Posner, one of the most conservative judges in the US courts, they described that this mere existence of summary judgments as an illustration how law, and specifically legal texts, actually contains a fictional imaginative element. So one example that we can imagine, and I'm sure you're all familiar with, is the common law case of Donahue v. Stevenson. If for those of you who may know, actually this case never extended beyond summary judgment. So whether or not there was really a snail in the ginger beer, we would never know. So how is the law capable of such creativity, such fluidity, and such malleability? This brings us to another clarifying question. Is the language of the law a dialect or a diglossia? By the former, I mean, is legalese a variant, such that it embodies characteristics of everyday plain language, but carries a unique vocabulary and grammar set? Or is it the latter? Is legalese a higher order of natural language, has nuanced deviations, but nevertheless carry forth the same fundamental grammar? Surprisingly, there are law and language scholars that support both thoughts. Ironically, scholars of the dialect group consider that legal language should not be distinguished from plain language. David Mellenkopf belonged in this category. In fact, he argued vehemently how legal language should be simplified and ensured that it does not include arcane vocabulary, such as removing all instances of Old and Middle English words. The legal language should correspond with plain language. For the aforementioned reasons, though, discussed in historical linguistics, it's not really an easy task. Natural language actually evolves over time. That is, Old and Middle English legalese was once actually plain English. It has, of course, since become antiquated. So Mellenkopf's recommendation requires necessarily that there must be some sort of continual exercise of alignment to ensure that legal language remains consistent with plain language. On the other hand, those who consider legal language as diglossia consider that distinct uses of arcane vocabulary and complex linguistic phenomena are actually highly intentional. Specifically, that there is actually a ritualistic dimension to law. Brenda Danet, both a sociologist and communication scholar, she described how legalese is a sort of thickened language, that the language is enriched with these literary features and precise uses of antiquated vocabulary for the very reason that legal language is not really only intended for communication. Put another way, the fundamental premise put forth by those of Team Dialect is that legal language must be expressible so that it is understandable for everyone. But for Danet, who represents, I'd say, Team diglossia, there's a different argument, that these specific linguistic characteristics of legal language perform functions beyond communication, and that there is some sort of aesthetic effect. So all is to say, what is the role of legal language? For those of you who may be familiar, there's actually a recent MIT paper that seemed to debunk this question. They applied natural language processing to understand the complexity of legal language. One of the key challenges actually of this hackathon is a question of accessibility, of course. So I've asked this before and suggested, is the language then a barrier against access? If so, would simplifying the language sufficiently improve accessibility? What's interesting about this paper is that it suggested that it was not complex, the legal concepts themselves, but actually that the language that was muddying the concepts. So what really is this relationship between complexity and accessibility? There's a counter argument for preserving legalese that stems beyond communication and suggests that actually embedded in this language, whether diglossia or dialect, is the DNA of history, culture, and power relations that cannot easily be simplified. To think that we could is to really reduce the law in substance. So in short, do we see a difference between clarification and simplification? So now we arrive actually at a crucial turning point, and especially as we are faced at the advent of technology. Is it possible to conceive of a legal language that is outside of natural language? If we take the premise that natural language has in a way shaped the way in which legal concepts are formed and have evolved, is there a place for computer code? These questions especially arise as, of course, this exponential interest in law and technology, but specifically a nascent field known as computational law. Computational law sets forth the idea of writing law in logic, and at its core, it considers how to represent the law between human and machine-readable languages. In a past article that I've written, I refer to this as the legislative syntax. I questioned this role of machine readability. Machine readability appears to bridge this desire for precision with its inherent logic and ruleness of certain aspects of the law. Machine consumable legislation may therefore be regarded as a product that evolved out of the relationship between syntax, structure, and interpretation. In other words, this recipe to resolve the complexity of legalese. While there are distinctions in literature between machine readable and machine consumable, for the purposes of today, I use them actually interchangeably. Since the 1950s, Layman E. Allen had fervently argued for the use of symbolic logic in the expression of legal concepts. In short, he demonstrated that symbolic logic was helpful to the extent of unpacking complex sentence structures. Nevertheless, there remain hesitations around the usefulness of symbolic logic for drafting. These arguments largely centered around the limits of symbolic logic in resolving complexity, but that it was beyond a question of increasing precision, but simply that most ambiguity is actually unknown. In other words, the law has an open texture and is inherently incomplete. I recall here my earlier example of bees as legally fish. There really isn't sort of a logical line that connects from one to the other. So with drafters of legislation governing the conservation of species, for example, have ever thought to include that bees could fall within the definition of fish? Recent implementations of rules as code fortified this argument that currently machine consumable legislation could only be limited to really highly structured legislation. The idea of using machines to encode legislation in a mathematically precise form would permit clear responses to legal questions. Nevertheless, rules as code leaves one question fundamentally unanswered, and that is, what should be the role of machine-readable legislation? Is it simply a coded version of the legislation, or is it a parallel alternative, one that is legally authoritative? Or is it a domain model of regulation from which third parties could then derive their own versions, akin to an open source code? These three scenarios each have their own sets of implications, and only in clarifying the role of machine-readable legislation would a fruitful assessment of how logic, syntax, and symbolic language are capable of representing legal knowledge. So in unpacking the role of machine-readable legislation, there may be a few hurdles encountered. The first, of course, is this familiar issue experienced with law in a bilingual state or further circumstances of bijuralism. Provided that perfect translation does not exist, there's inevitably potential for meaning to diverge, even if a common intent is established. This could foreseeably create statutes with multiple personalities, having dissonance between linguistic variants and heightening ambiguity interpretation. I'm actually originally from Canada, so I'll turn to Canada as an informative example. In 1995, the formal adoption of legislative bijuralism led to an acknowledgement of 4 legal audiences in Canada. And what I mean by bijuralism is that in Canada, it is a country that is both French-speaking as well as English-speaking. So we have a bilingual country, but that bijuralism that exists is that we also have an integrated civil law system amongst a common law system as well. And this is because of the unique state of Quebec and the colonial history. And so in 1995, there was a declaration that read that there is a right to read federal legislation in the official language of choice, as well as to find legislative terminology and wording to be consistent with the system of private law in effect of their province or territory. So as such, there is a constitutional requirement for all legislation to not only be written bilingually, this forcibly produced these makeshift equivalents in legislation, which were then devised without standard nor appropriate concern for the problems of interpretation. There were 2 models of producing this bilingual and bijural legislation. This is first translation and co-drafting. While they're perceived as distinct, the process around crafting this bilingual legislation often involves a sort of hybridization of both. This typically results in a conceptual mismatch between one language to another. So I take this example from Michael J.B. Wood, who provides a sort of fascinating illustration just around the word any. In the English language, any in the affirmative describes one out of a specific list. In the above example, the intention of the drafter may be just to indicate that these documents specified in the schedule, any of them could be included. However, for the reader, it could suggest in the rare case that any one of the documents specified in the schedule should be included. Consequently, in the French language example, there produced 2 variants. This lack of equivalence in the word any produces ambiguity between versions of legislation, both of which have equal authority under Canadian law. And this is just a simple example. Likewise, we see that the presence of both civil and common law systems within Canada led to further complications in the translatability of legal concepts. Bijuralism stipulates the requirement to have proper terminology and notions present across both systems of private law in Canada. To achieve this requirement, there were frequent methods used, such as the neutrality technique or something known as the doublet. The former is simply to use neutral terms, whatever that may be, in defining concepts without particular connection to either one of the systems. The latter is to enable the coexistence of legal concepts where there is no functional equivalent. In this case, what that means is that you would just write both, the French and the English sort of back to back. Both versions of this legislation are to retain their own identities. This means that paragraphs within the same legislation, they may intentionally signpost to direct how the rule of law is to be applied depending on the system. Both expressions of legal concept will obviously appear one after the other. Evidently, problems of interpretation arise as civil law terms are juxtaposed against common law expressions. Within the country, there were issues symptomatic of a conflict of laws, whereby courts applied common law definitions to jurisdictions that followed civil law systems. This led to inconsistencies in precedent, as civil and common law terminology were used interchangeably, without proper regard for the nuances of legality between each of these systems' interpretations. Canada has since made, of course, remarkable strides in legislative bilingualism and bijuralism. This is, of course, owed to reframing federal requirements as a strain of comparative law, as well as subsequent emergence of something known as juralinguists. Those are experts that are trained in both systems. But returning to the question of machine readability and authoritative code, what are some lessons that we can draw from this Canadian experience? And that is, there is actually a significant gap in both reconciling and harmonizing legal concepts between code and natural language. Perhaps the deeper question is whether and how that may be possible. In Canada, common and civil law terminology actually comes from existing traditions of private law. Their respective expressions are rooted in legal history. However, there is neither a comparable legal system nor a comparative field of law for code. That is, code not only has the potential of extending in alternative language, but it's not really a system of norms itself. The functional limitations of code could only be interpreted as linguistic limits, whereas the normative principles of programming, computer science, they could never really be perceived as parallel legal principles. The complexity then lies in the extent to which the linguistic medium has the capacity to alter the integrity and character of the law, even if the intention of its use is simply expression. Perhaps one of the most understated challenges with machine readability and rules as code hinges on the legal infrastructure itself. Across several possible approaches to machine readable legislation, there remains unresolved questions of design and interoperability between legal documents. That is, if a new symbolic language like code effectively enforced a controlled grammar, what are its implications as it moves across the legal ecosystem, in particular in interactions with various other legal sources? Legislation is one component among many that comprise the wider system of laws and rules. Statutes frequently reference one another, highlighting a process of synthesizing multiple inputs into a contextually dependent output. Provided that legislation is not perceivably independent text, it is then important to consider how machine-readable legislation could work in tandem with other legal documents. Consider, for example, this domain model-based regulation. Should there be a government-endorsed model from which legislation will be converted into third-party machine-readable versions, this could create inconsistent interpretations and thereby test the legal limits of the model. Currently, there is no standard for how the model translates to individual policies. More importantly, what might be issues of fit between various machine-readable documents, such as between machine-readable legislation to machine-readable contracts. In analyzing the coming of age of machine readability, it becomes clear that there remains a gap around its role vis-a-vis human-readable legislation, a challenge that this hackathon is no stranger to. Existing literature has focused on this promise of rules as code, as machine readability is sort of a magical formula for increased clarity and precision in legislative drafting. Yet this complexity of translating legislation from natural language to code actually stems from a conceptualization of legal concepts as independent entities, that the language itself plays little role in the construction of the concept. Legal information should then be considered at a systemic level to factor the interaction of legal documents with one across this temporally sensitive frame. And therefore, legal text should be perceived as objects with code as a semiotic vessel. How these objects could then interact, how references are made, and how their histories interrelate must be accounted for. As opposed to applying solely this arithmetic lens in the name of clarity and precision, language design for machine readability requires a contextual approach that extends beyond structure and accounts as well for this ontological reference. And without these considerations, machine-readable legislation could only remain in the realm of a computable iteration. So I conclude perhaps with a challenge as you venture forth through the hackathon. Consider the role that natural language has played in legalese, and more importantly, what characteristics of the language must be preserved and what might be made more accessible through formal logical language. So thank you, and I open up the floor to questions, as well as any comments and feedback. I'm always happy to kind of discuss more.
Thank you very much, Megan. It's absolutely fascinating, and we can see in your presentation, first of all, your passion for these topics, but also sort of a transition, right? We are in a period in law where we are kind of transitioning from a conceptualization of legal language that worked for many centuries to some new horizons that we feel we're getting close to. I will open the floor with a question around concepts and objects, because this is something that I find really interesting also from the point of view of accessibility of legislation. So if we go towards a world where we will be dealing with essential legal objects, concepts that get encapsulated into an object, similarly to what happens in computer programming in terms of object-oriented programming, for example. Then there are things that we could do. There are attributes of those concepts and objects that could, for example, be automatically updated. Say, for example, we would be able to have a law that contains an object, if you like, that has a certain judicial interpretation at a certain point in time, but we would then be able to see that object evolve as its interpretation in the courts also evolves. So I was wondering if if you see this as a path towards accessibility as well, in the sense that we would be able to, without necessarily updating the language of the law, we may be able to update the content of the law, if you like, as things progress and interpretation changes.
Yeah, absolutely. So I think that that's a fascinating question itself, is should we step outside of the paradigm of language altogether? And as you mentioned, we're sort of at a breaking point or at the limits of this, or, we're entering into an era where we're allowed to ask, is natural language really the right medium? And what you really point to in object-oriented programming, that's actually a great paradigm, or a great computing paradigm that, or programming paradigm that many sort of programmers have thought about as one that might be very compatible with the law. And beyond sort of object-oriented programming, I know that I'm familiar with the project, the Regulatory Genome Project. They focus a lot more on financial regulation, and what their sort of key is that it's beyond language. What they're trying to extract is the data itself, and that we can reproduce the data, and that's sort of how you can allow the law to grow. I certainly agree with all of these points. And of course, there's a kind of tension and conflict that was mentioned probably in the earlier session, and is who is actually engaging with the law? Who is the kind of user at this point? Are we thinking about sort of the everyday person, where the language of the law actually has already been a barrier? And so you don't really want to kind of focus on the legalese. And so gathering sort of the kernels of information that I need and sort of extracting that information is sort of what I want. That is going to be really helpful in terms of accessibility. But to kind of the lawyers and judges who are still trying to navigate grounds outside of natural language and to live in a paradigm that exists outside of documents and outside of language, how do we sort of reconcile that? And I think that's sort of the bigger question here is, what should the law be serving? And not what, but who really? And I think it will take a while before we can get to a state where we have sort of almost various views in a sense. And currently sort of at the work that I'm doing at the moment, I work specifically in computable contracts. There's a contract object model that Professor Harry Cerdan, he's sort of the pioneer of the area of computable contracts, he's kind of heading towards. And what he was mentioning is that everyone approaches the law in a sort of different manner. Some people, text will always be a point of entry. But for others, there might be visualizations of the law. And you see that with legal design, or the area of content design applied to law. I always use this example, but I'm really amazed at the work of Robert Del Roy, who works on comic contracts, where he decided to take contracts and turn them into comic strips, such that those who may be migrant workers who may either are illiterate or unfamiliar with the actual language in which the contract was written are able to still understand their rights. And so I think when we are asked, is it necessarily code that we have to write the law in? Is object-oriented programming, or what paradigms should we be using? I think we should always center on who sort of is the end user, in a sense, who is actually going to be approaching the law, and that maybe the law should be regarded through multiple mediums as opposed to solely the medium of natural language, and more specifically legalese.
Fantastic. That's really, really interesting. Thank you, Megan. Any questions from anyone for Megan? I see camera being switched on.
Hello. Thank you very much for this very interesting presentation. I wanted to ask, at what stage do you see this translation of the legal text into a symbolic language being applied? I mean, would it be a step following the initial drafting of laws, or would it be a parallel process?
Yeah, that's a great question. So I think it depends on sort of how you want to approach, and the question I ask about sort of what role do you see in machine readable legislation, or what role do you see even in using logic to construct legislation? For example, if you're familiar with Català, the language that was created by Denis Merigot, and Leanne Hutner, what they did was something called parallel drafting, which is also used, that exists in sort of bilingual and bijural countries such as Canada, where simultaneously, in theory, you have someone who's a French speaker and an English speaker drafting legislation in parallel. Some ideas that were put forth that were sort of kind of reminiscent of paired programming, which is common for computer scientists, is that you have a programmer with a lawmaker or a lawyer kind of simultaneously drafting. So that's sort of one stage that we can envision. The other sort of side of it, that something that we're currently working on, at least over at Codex where I work, is this notion that we determine certain parts are compatible with logic. And so what I mean by that is specifically, we're working with industry partners and in creating contracts. And while most of sort of the contract we might want to retain in natural language, there's some parts that are quite amenable to logical construction. And actually it would improve if we kind of use logic. And so given insurance as an example, we use it for coverage checks. So for those who don't know, in the US, insurance is a major problem. Most people don't read their insurance policies. And I'm sure for many of you who've bought, their motor vehicle insurance or home insurance, when was the last time you read this, 100-page document? Probably never. You probably just trust whoever sold it to you. So what we're trying to do over at Codex is actually determine something called a coverage check. We're going to craft sort of these insurance policies as sets of conditions and conclusions, such that the person that is, or the consumer that is interacting with the policy, they can just say, these are sort of scenarios I have. Am I covered? Yes, no. And so we could imagine, a similar structure existing for legislation, meaning that the person who is engaging with the legislation doesn't care so much about, reading it and getting into the nitty-gritty of the text itself, but really they're saying, I have this problem. Will this legislation account for it? Am I covered under this scenario? So that's kind of another sort of methodology that we're thinking. So it really depends when you discuss sort of progress is when we translate, do we want to work in parallel, or do we want to think of ways of conquering and dividing what we think certain languages, and I use language as both programming and natural, have a better role in some parts than in others?
Thank you very much.
Thank you. Sarah, I think you also had a question.
Yes, I did. Thank you. Thank you for your presentation, Megan. It was really interesting. And you've sort of touched on my question a bit in your presentation and a bit in your last answer. But this hackathon, we're looking at accessible legislation. And I'm just wondering, when we sort of start coding or sort of using computer language to communicate the content of legislation, and the risks around actually changing what that legislation is, because we're applying another level of interpretation in a sense. I know you've sort of unpacked that a little bit, but yeah, I just wondered if you could sort of give us a bit of guidance around sort of, we don't want to get into that territory of changing what the legislation says. And then also I was thinking through, and not so much in the UK, but in the pluralistic legal context, when you've got perhaps unwritten laws, or perhaps in more indigenous, perhaps experience from Canada, how around coding, computer coding for those kinds of situations as well.
Great. So those are some great questions. Thank you so much. So to your first one, I certainly agree with you. There's a huge concern about whether or not we've interpreted correctly. And when I speak to many sort of computer scientists, they often respond with, well, when you interpret in natural language, you don't actually even know if you're interpreting it correctly. And so sometimes that's sort of their rebuttal in this idea, but I tend not to think about translation sort of between the languages. sometimes I wonder if the approach of the parallel drafting, for example, is something that we should think about instead, is that we're sort of working together. And this is sort of the interdisciplinary exercise of accessibility, is that because you sort of have someone, instead of the sort of computer scientist or the notion of coding as almost a layer after the natural language construction, you're kind of working through it as a team. And so the legislative drafting process is sort of also a team effort alongside, someone who is writing it. And of course, I say that parallel drafting exists in Canada, but actually, having worked in the government for a bit, you realize that that is very rare. Most of the time it is already drafted in English and then translated to French or vice versa. And so, of course, kind of what I'm saying right now, it might be taken obviously with a grain of salt, and that we don't really have maybe the time and effort, because a parallel drafting effort takes quite a bit of time. It takes quite a bit of patience, because speaking between disciplines is, in a sense, a type of translation itself. And in many cases, you've seen that there are terminology that are the same word, but actually applied differently between each discipline. And one that always comes to mind for me is the notion of fairness. Fairness for computer scientists is very different from fairness for lawyers, and even for those, with socio-political backgrounds. And so in kind of working in this type of space, we have to reconcile kind of many angles of translation, not just kind of construction from the get-go. And one thing that we also need to remember, or should be reminiscent of, is this idea that the law, even if you are drafting new legislation from the start, it's seated within sort of legal history that you can't really get rid of. And all of that was encased in natural language to an extent. Even earlier, there's other forms. To your question about sort of Indigenous populations, many of their laws are actually communicated verbally and passed down. And so actually it is not written per se. So the question of translation is sort of inevitable, and being able to interpret. And a lot of sort of linguists, they have this idea of this third dimension called pragmatics, is that we sort of have this sort of probabilistic way of interpreting each other, is that we keep going back and forth. We're like, these are sort of standard conditions in which we may understand, but we are always approximating meaning. We could never necessarily ascertain it. And so just keeping that in mind, you might say that, in natural language, we're all used to it because we're humans, but as the computer scientists say, we might not actually even know what either of us are really interpreting out of the conversation or out of kind of what we read in text. And naturally, that's why, we have poetry and all of these things where multiple interpretations exist. And so I think I encourage sort of on both questions is it may not necessarily require us to have this mindset that we need perfect translation, because simply that doesn't exist, but merely that there is sort of this this goal or end goal, and I always oriented around it as just focusing on who might be engaging with those types of legislation. And something that sort of Fred had mentioned in the earlier session is lawyers tend to think, they're the ones that are engaged with it, they don't see a purpose for it. But ultimately, maybe the social beneficiary is someone that we should be thinking of and should be mindful of. And so accessibility is really a question of accessible to who, as opposed to kind of getting into the weeds of, is this perfect translation? Have we interpreted correctly?
Yeah, actually, your answer there also reminds me a bit of when we first got European law in the UK, and we were like, how do we interpret domestic law in line with European law across all the different sort of signatories? And again, kind of the guidance was apply kind of what the meaning is of the law, interpret it in line with the meaning of the law. So I guess that's similar to your pragmatics approach a bit of sort of what's the intention of the legislation. But yeah, thanks very much.
Yeah, and to your point, like I think quite a bit of the law, as opposed to being communicated, is something experienced. And so sometimes I think that I always see law as a form of literature to an extent, and I think that we're always in a truth-seeking exercise, but really we should be thinking about what narrative do we want to create out of the law, and out of this sort of tool in itself that we've seen to like sort of shape and construct society. So.
Yeah, thank you.
It's so interesting how something that, you know, seems to be sort of the outer sphere of law, the way in which law is communicated, if you like, it really becomes a question about the law itself and what law actually is. But it's almost the more we talk about it, the more we seem to not only transform the way in which we apply law or communicate law, but the nature of law itself is brought into question, which I find very interesting. Any more questions for Megan? No? If there are no more questions, we've had a very... Caitlin, yes?
Yeah, I was just going to ask a wee bit about your experience working in the Canadian government, and asking, in a drafting office that is bilingual, do you think there's a space for a third language, a computer-based language as well?
I think there's certainly, so I hesitate to fully say, and the reason is because much of Canada is actually English speaking. There's really sort of a focused sort of number of states or provinces that speak French. And so some of the discussions I mentioned, this kind of laziness of having the piece of legislation written in English already and then just given to a translator and put into French. That's actually sort of the modus operandi in the state where I grew up, which is in Ontario. And so I'm from Toronto originally, which is English speaking. But what I actually see in practice is in Quebec, where they are actually French. They are much more mindful to kind of write in parallel and actually exercise parallel drafting. And that is because quite often they receive cases that are originally, or plaintiffs that are originally English speakers or English speaking plaintiffs that will be applying sort of their legislation in the English sense as opposed to just French. And so when it comes to kind of this added layer, I think it always goes back to the question of what do we see as the role of machine readable legislation? And what do we want sort of out of this third kind of language? Because it'll add resources and it will add sort of to the process. But are there certain types of legislation at the moment where actually both the English and French are sufficiently sort of blurry and muddied that we feel the need that the machine readable legislation, for example, could provide a sort of third dimension? Because as I mentioned, sort of in Canada, we already somewhat face a conflict of laws internally. There are actually a number of cases where actually English-speaking plaintiffs have decided to take the French version because the French translation had a more amenable sort of definition than the original English. And so if we add kind of this third dimension of the machine readable side, we have to be quite cognizant of what that will do. And the machine sort of, in terms of programming languages, they themselves have their own paradigms. Many programmers will say that they come from sort of different origins, the way that they had learned programming. So in that case, you're kind of adding a more complex kind of paradigm as to the sort of, I guess, background or all this history of how they've learned how to program or how they've come to understand this language, and that kind of layer onto sort of existing natural languages. So it's not just, I think, how do you translate into that third language? It's how would that sort of third machine readable language have an impact on the existing legislation? I don't know if that answers the question.
Yeah, I think it does. It's just as soon as you incorporate another language, you've got to think about the impact in which that causes.
Mm-hmm.
Brilliant. Okay, so I assume that there are no more questions for Megan. I'm looking at my screen, but I can't see anything else. So Megan, let us give you a really big thank you for joining us today. It has been really, really nice to hear about your research and also your passion for this field. And thank you for sharing it with us.
Yeah, thanks so much again.
Thank you very much. And that concludes our first day. So we hope that everyone enjoyed it, and we